Are you looking for a way to protect your assets from lawsuits and aggressive creditors? If so, a Cook Islands Trust could be exactly what you need. Individuals and companies have used Cook Islands Trust's favorable laws for decades to hold on to their assets when lawsuits threaten to take them away. My goal for you is to make this the most complete video on Cook Islands Trusts, presented by the guy who has set up more Cook Islands Trusts than anyone on the planet. Asset Protection Planners has been helping people establish effective offshore asset protection trusts in the Cook Islands and elsewhere for nearly 3 decades. And using the knowledge we've gained over the years, we put together a detailed guide on what Cook Islands Trusts are, how they work, and who needs them. So first, what is a Cook Islands Trust? A Cook Islands Trust is a type of offshore asset protection trust established within the Cook Islands, a chain of 15 small islands located northeast of New Zealand. While these islands originally gained fame as a tropical vacation destination, now they're better known as a home for ironclad asset protection trusts. More than 40 years ago, the Cook Islands passed the Cook Islands International Trusts Act of 1984. This laid out the legal framework for offshore asset protection trust establishment within the Cook Islands. It also codified the commonly cited benefits of Cook Islands trusts, namely asset protection from lawsuits, the right to refuse foreign court rulings, and confidentiality. In 1989, the Cook Islands legislature amended the International Trust Act, and these amendments were primarily focused on strengthening existing asset protection statutes. In particular, these amendments allowed the settler, that is the one who established the trust, to be listed as a beneficiary of the trust. Now, prior to this, most asset protection trust laws required one to give assets to a trustee without retaining beneficial interest in the trustor's assets. Cook Islands' robust statutes led other jurisdictions, such as Nevis and Belize, to imitate these provisions. And then ultimately in 1989, amendments allowed for the creation of trusts that protected assets in ways that no other jurisdiction did at the time. The first jurisdiction to offer such laws, the Cook Islands, has a significant case law history, which further bolsters the protection provided by their trusts. To make their protections even stronger, the Cook Islands government goes to great lengths to ensure that all trusts under its jurisdiction are ethically established, legally operated, and properly regulated. These trusts are not used to hide assets. Instead, they are designed to help keep your assets safe. Thanks to these strict regulations, the Cook Islands are internationally viewed as a respectable trust establishment jurisdiction. This sterling reputation helps make it nearly impossible for lawyers to portray such trusts as anything but legitimate. The international respect afforded the Cook Islands Trust, coupled with their ability to protect assets from a variety of threats, has made them a popular choice for individuals hoping to guard their wealth. And according to the Cook Islands Financial Supervisory Commission, there are 2,200 to 3,000 trusts created per year as of this video. Of the countless organizations that set up trusts, we have established more trusts, as I said, than anybody else in the world, and have been creating Cook Islands Trusts since 1996. The history of trusts themselves. Now, trusts have been around since the 11th and 12th century Crusades, when William the Conqueror created the Common Laws of England in 1066. As part of common law, soldiers who headed into battle could transfer the title to their land to a person they trusted, and this ensured that the land could still be used productively for the crown. For centuries, trusts were used domestically, and while they provided some level of protection, it was not ironclad. And that all changed when the Isle of Man codified the Trustee Act of 1961. Now, this act addressed the powers of trustees and covered how trustees are appointed and discharged. Furthermore, it plainly laid out the capabilities of the courts, limiting their ability to reach trust-held assets. And by painstakingly detailing the function of trustees and the extent of court powers, this act turned the Isle of Man into the world's premier offshore asset protection trust destination at the time. And then eventually, the Cook Islands legislature teamed up with U.S. attorneys to create an even more favorable environment for asset protection trusts. The protections they created surpassed those of the Isle of Man, and since then, the Cook Islands have supplanted the Isle of Man as the top destination for offshore asset protection trusts. Asset protection experts consider the Cook Island statutes far more protective than the Isle of Man statutes. Nevis has since copied and improved upon the original Cook Island statutes, and as a result, Nevis has shown itself as a very favorable jurisdiction as well. Since trusts have been around for nearly 1,000 years, courts are exceedingly familiar with how they work. Centuries of case law shows that if there is a foreign trustee of a properly established trust, it effectively protects assets. With such strongly established precedents working in favor of asset protection trusts, they're really the ideal way to maintain asset safety against creditors and lawsuits. So here are some features and benefits of Cook Islands Trusts. Cook Islands Trusts provide dozens of benefits for wealthy individuals, and the benefits of this kind of trust are made possible by a rich history of ethical and legal trust establishment, long-standing case law histories, and strict confidentiality rules. And to help you better understand the value of Cook Islands Trusts and what they provide, we've laid out some of their primary features and benefits in this video. Benefits of Cook Islands Trusts. Here's a quick overview of the primary benefits and features of a Cook Islands Trust. Strong asset protection case law history, so you know it works. Part of New Zealand, one of the most trusted and least corrupt countries in the world, according to Transparency International, does not recognize foreign judgments or court orders. So a lawsuit back home doesn't take your Cook Islands assets, requires an opponent to file a costly lawsuit within the Cook Islands, which they would most likely lose, offers immediate asset protection, so you'll be protected right away. Subject to debtor-friendly laws, so your opponent faces a huge barrier. Courts will reject challenges to asset transfers into the trust after the statute of limitations of at least 1 to 2 years has expired. So your opponent is dead in the water. Assets can be located anywhere in the world, so we can use super safe banks such as those in Switzerland. Transfers to the trust can be made over the internet, so it's very easy to use. One of the oldest and most trusted international asset protection trust structures, so it's stood the test of time. Creditor must prove its case beyond a reasonable doubt, so the level of proof is usually that reserved for criminal cases. Therefore, your opponent faces a guarded fortress of protection. Creditor must prove that the settlor created the trust to defraud not just any creditor, but that creditor in particular. So it makes it almost impossible for your opponent to win. Offers estate planning and international diversification, so you give a more court-friendly reason for setting it up. That is, a reason other than just asset protection. Offers significant confidentiality, as trust deeds are not publicly recorded, so the public won't know how much you have. Allows for a variety of investment options, so you can put money into stock, bonds, and gold, etc. Protects assets even after the settlor or beneficiaries declare bankruptcy. Okay, so here's how to use Cook Islands Trust to protect your assets. A properly created and maintained Cook Islands Trust always provides some level of asset protection. However, the ability to strengthen that protection by applying another layer of separation between you and the assets in the trust are processed as this. Number one, setting up a limited liability company or LLC with you as the initial manager. Number two, putting the LLC into the Cook Islands Trust. Number three, creating a bank account in the LLC's name. Number four, depositing your assets into the LLC-owned bank account. So the Cook Islands Trust owns a Cook Islands LLC, and the Cook Islands LLC owns your bank account. And once this process is complete, the trust owns 100% of the LLC, and as the initial manager of the LLC and signatory on its bank account, you remain in control of the LLC and the account that it holds, while the legal seas are calm. During this time, you can move funds in or out of the LLC from or to any location in the world. You can sell or add tangible assets. You can work with the trustee to amend the terms of the trust. And naturally, you'll do these tasks within the bounds of the law and protective provisions as your personal or professional situation dictates. And then when the legal seas get stormy, your trustee, which is our Cook Islands law firm, can step in as manager of your LLC. Your local courts do not have legal authority over our international law firm. Thus, orders to return the trust funds to your local courts go unanswered. You're cooperating, but your trustee company law firm is not under any legal obligation to do so because they're outside of your court's jurisdiction. Therefore, your funds remain secure within the trust. Now, keep in mind the primary purpose of placing the LLC within the trust is to provide a means for you to control your money as the manager of the LLC. Additionally, it makes for an easy transition when you need the trustee law firm to step in to secure your funds. So the purpose of establishing a Cook Islands Trust is not to conceal your assets from the government. It is to protect them from lawsuits. Any personal or business taxes due on the income that your assets generate are still your responsibility, making the structure tax neutral. So who should consider a Cook Islands Trust? Cook Islands Trusts are ideal for a wide range of individuals and entities, including high net worth individuals, those with significant assets who want to protect their wealth from legal threats, business owners, entrepreneurs looking to safeguard their business's assets from potential losses of creditors, those in high-risk professions such as physicians, lawyers, and other professionals who face high risks of being sued. Estate planners, individuals who seek to ensure a smooth transfer of wealth to future generations while minimizing estate taxes. Now, who should not consider Cook Islands Trusts? Cook Islands Trusts are not for everybody. Here are some examples of who should not consider setting up such a trust. Tax evaders. Tax evasion is illegal. We are legally forbidden from accepting clients who clearly intend to use a trust for tax evasion purposes. Criminal defendants. Cook Islands regulators forbid the establishment of a trust intended to hide assets during a criminal case. Government civil defendants. FTC regulators will not allow defendants involved in a lawsuit with a government agency such as the IRS, SEC, or FDA to establish a trust to protect assets. And we're not permitted to do so either. Insufficient asset value. For those with less than $250,000 to $500,000 in assets, we offer more economic options to protect wealth. So here are some common uses of Cook Islands Trusts. Cook Islands Trusts are primarily used to protect assets against external threats. However, that's not their only purpose. Here are additional examples of how one would use an asset protection trust in the Cook Islands. Pre-divorce or premarital planning, so you keep your assets even in a divorce. Leverage to negotiate a legal settlement, so your opponent can't force your hand. Estate planning, so your kids get your money when you die. Wealth preservation, so you keep what's yours. Family legacy planning. Cook Islands Trust can last indefinitely. Avoidance of forced heirship, so you can choose who inherits your assets instead of being forced to give your estate as the government dictates. Protection from lawsuits, so you get to keep your money. Stock market portfolio management, so your money can grow. Retirement planning, so you can live off your investments. Intellectual property protection, for example, patents, copyrights, and trademarks. Real estate asset protection with equity stripping and other strategies. So here's how to set up a Cook Islands Trust. To ensure you receive the maximum amount of asset protection afforded by a Cook Islands Trust, you must set it up properly. So follow these 5 steps to ensure that your trust is compliant with local regulations. Number 1, seek professional guidance. The first step in creating a Cook Islands Trust is to consult with a seasoned asset protection firm. If needed, Asset Protection Planners has attorneys and consultants on staff who can discuss your needs. Working with professionals will help you remain compliant with legal requirements, ensuring your assets are properly guarded against creditors and lawsuits. Number 2, identify key trust parties. Working alongside your professional partner, you will have individuals serve in the following roles. Settlor, the individual establishing the trust, such as you. Trustee, our licensed trust company law firm in the Cook Islands responsible for managing the trust. Beneficiaries, individuals or entities who will benefit from the trust. Protector, which is optional, and this is an entity or person outside of your local court jurisdiction with oversight powers over the trustee. Again, this is optional. Number 3, draft the trust deed. This legal document will be drafted by our in-house attorneys, and it outlines the terms, conditions, and parties involved in the trust. It serves as the foundation of your Cook Islands Trust, detailing the roles and responsibilities of the settlor, the trustee, the protector, and any beneficiaries. Number 4, complete the necessary documentation. Now, to establish a Cook Islands Trust, you'll need to prepare and submit several key documents, including the following. A certified copy of the settlor's passport or driver's license, so they know who you are. Proof of address, utility bill, or bank statement, so they know you're really who you say you are and not a terrorist pretending to be somebody else. Evidence of funds, a bank reference letter to show you didn't make your money from drug dealing. A signed Money Laundering Control Act and document of solvency affidavit, saying you're going to use the trust legally. A deed of indemnity, which protects the trustee from acts made in good faith. Now, these documents are essential for the trust company to perform due diligence and ensure compliance with international regulations. Number 5, transfer assets into the trust. The final step in setting up a trust in the Cook Islands is to transfer your assets into the trust. And once the assets are transferred, they are legally owned by the trust and are protected against legal claims and creditors. Now, here's a little bit about Cook Islands Trust costs and maintenance. Now, setting up and maintaining a Cook Islands Trust involves several expenses, including the setup cost. Now, this varies, so inquire and talk with one of our professionals. Annual maintenance fees, which are usually in the $5,000 to $10,000 range, depending on when you're watching this video. Additional entities, the LLC that goes inside of the trust, and real estate asset protection cost extra. Additional costs, reporting and compliance, tax preparation, and trustee fees. While the Cook Islands Trust costs may seem significant to some people, they're usually a lot smaller than having your assets taken during a lawsuit. Additionally, the cost of creating a trust through asset protection planners is far lower than the average cost of trust establishment because we establish so many. Now keep in mind that the renewal costs are an estimate and not a guaranteed price range. And once established, you must continually manage your trust. The key activities involved in trust maintenance are annual fees. You need to pay the required annual maintenance fees to keep the trust active and compliant. Compliance. It's important to ensure that the trust complies with all relevant legal and regulatory requirements. We assist you with this step by staying updated on regulatory changes. Updates. You should make any necessary updates to the trust deed and other documents to reflect changes in your financial situation or estate planning goals. And we can help you with that as well. So to assist you with maintenance processes, we provide a registered office that can help remind you about filings to renew your trust annually. So what role do trustees play with Cook Islands Trusts? A trustee's sole purpose is to protect the assets of the LLC within the trust. Let's say a court issues a judgment against you that could threaten the assets included in your Cook Islands LLC. At that point, your trustee steps in temporarily and take over the reins of the LLC by becoming its manager. Now, if you were in full control of the trust and were ordered by a court to turn over your assets, you would have to comply. Likewise, the trustee of a domestic trust, that is a trust in your home country, must comply. For that reason, even popular domestic trusts like those in Nevada, Wyoming, and Delaware lack the efficacy of an offshore asset protection trust. However, with a Cook Islands Trust, the trustee is not under the jurisdiction of your home country, so the orders fall on deaf ears. As a lawful citizen of your country, you are obliged to instruct the trustee to obey the court's ruling. So if you had control, you would have to surrender your assets to the court. So you being in control is not you in control, it's the judge being in control. So the court, in turn, would grant them to the person or entity who won the lawsuit against you. However, the verbiage we place in the trust prevents trustees from releasing funds within the trust to the courts. When a person requesting this action is under legal duress from a legal opponent, the trustee will refuse to comply. That's called the duress clause. And this is the case if a judge was compelling you against your will with a court order. Impossibility to act. The aforementioned scenario places you in a legal situation known as the impossibility to act. You have fully complied with the court ruling, but your legal enemy cannot access your assets. And this is because the trustee, acting in accordance with the asset protection laws of the Cook Islands, will not release them. In other words, it is out of your hands. And this is not mere legalese, nor an example of sleight of hand. This is a legitimate countermeasure that you can employ through our trust company law firm to preserve the assets that you placed in your Cook Islands trusts. The trustee is your ally. Given that the trustees are often someone you don't know and are in charge of a significant amount of your assets, it's normal to be wary of the power they wield. However, they are always on your side. The laws in the Cook Islands regarding the licensing of trustees are clear, comprehensive, and strictly enforced. Moreover, the government thoroughly vets the trustees and makes them hold surety bonds, insurance that protects you, the client. Plus, regulators thoroughly research trustees' backgrounds prior to issuing them licenses. A licensed trustee company is therefore eligible to take over as a manager of an LLC within the trust when needed. Even in the highly unlikely event that a trustee misappropriates your assets, which we've never seen, the surety bond they hold makes them liable for failure to properly manage the trust and force them to pay you back completely. Surrendering the control of your assets may make you nervous, but losing them altogether because they're in your control is an even worse scenario. So we invite you to look into the history of the Cook Islands trustees, and you'll find a heavily regulated industry with a long-standing track record of proper fiduciary responsibility. And ultimately, the risk of a trustee acting against your interest is far lower than the risk of your assets being taken as part of a lawsuit. So when legal troubles arise, having the trustee step in as the LLC manager as a temporary and prudent step that averts the possibility of losing your assets altogether, when the legal crisis passes, the trustee will cede control and management of all of your assets back to you. Moreover, our organization has had relationships with Cook Islands trustees for nearly 30 years. We believe what you do and not what you say philosophy. Thus, we have observed and vetted the trustee companies over a period of decades. If needed, you can use a portion of the funds in your LLC to cover certain financial obligations. This may include living expenses, business expenses, and legal expenses. Your trustee can cover these financial obligations for you. So we recommend this course of action in the event where the courts prevent you from directly accessing your assets. We automatically draft the trust with this contingency plan ahead of time. So here's what to keep in mind when creating your Cook Islands Trust. While Cook Islands Trusts are incredible tools for asset protection, there are a few factors to keep in mind. Now, most notably, creating one of these trusts requires you to use a foreign trustee whom you may not know. Fortunately, trustees are beholden to strict rules that dictate what they can and cannot do with the trust while it is in their possession. Additionally, if you're a U.S. person, once you establish a trust, you need to adhere to certain Internal Revenue Service, or IRS, and Financial Crimes Enforcement Network, or FinCEN, reporting requirements. You will need to complete these reports every year, and failing to do so can lead to civil or criminal penalties. While on the whole, this fear of the unknown pales in comparison to the risk of leaving your assets unguarded and leaving them open to seizure. Additionally, working with a respectable trust establishment group like asset protection planners can render the potential negatives moot, as they have a connection with reputable trustees who can assist with reporting requirements. Setting up a Cook Islands Trust with the help of asset protection planners. When properly set up, your Cook Islands Trust can effectively protect your assets from frivolous losses. In addition, it can help you secure your future and ensure that your assets are used only for the purpose that you've envisioned. If you work in a field that has a higher risk of litigation, such as the legal or medical fields, you are a wealthy individual, or simply want to prepare for the possibility of a lawsuit, consider setting up a Cook Islands Trust to protect your assets. And doing so will give you the most precious and priceless commodity of all, peace of mind. So contact us today by filling out the form at assetprotectionplanners.com to start your trust formation process. Subscribe for more. This is The Business Guy.